the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, His Honorable Court.
Please be seated. We'll hear argument in 3 cases this morning. First is 19-1108, Texas Commission on Environmental Quality versus Maverick County from Travis County and the 3rd Court of Appeals District. Then 2309, City of Baytown against Schrock from Harris County and the 1st Court of Appeals District. And finally, 2517, U.S. Bank National Association versus Moss from Dallas County and the 5th Court of Appeals District. The court has allotted 20 minutes per side in each of the cases, and we'll take a brief recess between the arguments, finishing them before lunch. The arguments are being webcast live this morning on the court's website and will be available later in the archives. We'll hear argument in 19-1108, TCEQ versus Maverick County.
May it please the court. Ms. Caughey and Mr. Davis will present argument for the petitioners. Petitioners have reserved 4 minutes for rebuttal. Ms. Caughey will open with the first 8 minutes. Ms. Caughey will present the rebuttal.
And let me add also that Justice Lehrman cannot be present this morning, but expects to participate in the decision of all 3 cases. Ms. Caughey.
Mr. Chief Justice, may it please the court. If I may, I'd like to focus my 8 minutes on the operator issues, and then Mr. Davis will address the issues the commission briefed. This appeal arises out of the renewal of a long-standing wastewater permit issued to my client or its predecessor since 1994. Interpreting its own rules and the extensive administrative record before it, the commission concluded that my client was the owner and operator of the mine for wastewater permitting purposes and renewed the permit. The administrative law judges reached the same conclusion. The Court of Appeals, however, concluded that my client was not the operator of the mine for these purposes, and instead our contractor was. There are 2 fundamental problems with the Court of Appeals' approach. First, it disregards plain text, and second, it disregards the deferential substantial evidence standard, which requires affirming the commission's determination regardless of which definition of operator you choose. I'll start with the plain text. There are 2 commission rules at issue here. In the first, the commission explains that for wastewater permitting purposes, an owner and operator apply regardless of whether they're the same entity or not. Second, the commission sets a baseline definition of operator for these purposes as the entity responsible for the overall operation of the facility. Now, the commission could have chosen a number of different definitions of operator. The Railroad Commission, for instance, deems an operator anyone who removes a certain amount of coal from the ground. But the commission chose the word responsible, which means liable to be called on for, and overall, which means taking everything into account. The Court of Appeals erased these words from the rule and replaced them with personal performance, saying that by definition, always an operator can only be the entity who's responsible for its personal performance of causing the mine to function. Well, this risks sweeping in countless contractors across Texas who lack decision-making authority, are not responsible for overall operations, and that's directly contrary to the text, and it's directly contrary to the history and purpose. Originally, Texas only required owner permitting, with an explanation in the Texas Register that in this context of wastewater in Texas, it was often, the owner and operator were often one and the same, and it was often the owner who had the ability to effect change and ensure permit compliance. In the 90s, Texas took over permitting, the federal permitting system as well. And EPA had expressed a concern that when owners and operators were different, there could be instances in which the only permittee under an only owner permitting rule is an absentee landowner who has no involvement in any way in operations. And so what Texas did here was quite reasonable. They said, okay, we are going to permit the owner and operator. If they're one and the same, great, we're covered. And if they're different, then we have the owner. And even if that happens to be a completely absentee owner who just owns the land and is wholly uninvolved, we have the person responsible for overall operations who can effect change and ensure compliance with the permit. Well, when you look at that Texan history, there's no question under the substantial evidence standard that we sail over it. The commission issued findings of fact 40, 41, and 42, all of which were well supported by the testimony of the president of my client, the president of the contractor, and the contract itself. Look, for instance, at contract provisions 3.3, 5, 7, 8.1, 8.6, 9, 10, 12.5, and 26, and 16. What all of these show, along with the testimony, is that no operations happen on this mine without my client. We are the ones who determine the amount and quality of the coal to be mined. We have to approve every plan and budget before action can be taken. Every plan includes the design plans, the life of the mine plans, the annual mining plans. And as 8.6 of the contract makes clear, along with the testimony, the contractor lacks discretion to depart from these plans that we have approved. We have the ultimate say in whether subcontractors will be hired over inventory. We have ultimate financial control, but that financial control on this record is linked to operational control. This isn't just a record that shows that we own some land and are wholly uninvolved along the lines of where EPA expressed concern. Our financial control, as Mr. Koss testified, is directly linked to operations. We oversee permit compliance and have responsibility for it. And so looking at
a couple of points that you might address. Number one, Camino Real, the contract says that they're being hired to operate, right? Construct, develop, and operate the mine. And number two, didn't your client, when it applied, it had the option of choosing owner, operator, or owner and operator, and it chose only owner, which seems to suggest even your client didn't think it was the operator at the time of the application. Will you address those?
Absolutely, Your Honor. So first, on the contract saying operator, it says that we hired them to operate the mine pursuant to the terms of the agreement. You read the contract as a whole, and when reading it as a whole, it makes clear that they only operate under our direct approval. They can't do anything without us. So when you ask who is responsible for overall operations, even under the Court of Appeals' interpretation, we sail over the substantial evidence standard because we're still, the buck stops with us for our personal performance. Without us, this mine can't function. But they cherry pick provisions of the contract, but read as a whole, the contract supports us. And in any event, the substantial evidence standard says you look at the whole record, and there's evidence and testimony supporting us as well, certainly more than a scintilla. To your second question, Your Honor, of the checking the box. Number one, if you continue on in the record of DR 107, they reference a 2-page form. Well, right after that is our actual application. And in the actual application, we identify ourselves as the owner and operator, the only permit applicant. Number one. Number two, this court already determined in Denbury and the Court of Appeals determined in Heritage that a mere checking of the box is not conclusive of your legal status. Number three, it is for the commission to determine who qualifies as an operator for these purposes. And number four, this all comes back to the deferential substantial evidence standard, and at most that could be some evidence in their favor, but it certainly isn't conclusive. And I see my time is up, Your Honor. Thank you. there are no further questions, I will,
Any other questions? Thank you, Ms. Coy.
thank you.
We'll hear from the commission.
Thank you, Mr. Chief Justice, and may it please the court. I'd like to focus my time, if I could, on two of the questions that the commission presented. The first is whether the Court of Appeals' conclusion on the owner-operator point that Ms. Coy just discussed deprived the courts of jurisdiction to reach the other challenges to the commission's order. And then the second is whether the commission's modification of the SOA judge's proposal for a decision was authorized by statute, and whether the general APA standard or the specific TCEQ standard governs that amendment. So on the first point, it's not entirely clear why the Court of Appeals thought that its reasoning deprived it of jurisdiction. That part of the opinion is just a single paragraph right before the conclusion. And APA section 2001.171 allows for any exhausted issue to be raised in judicial review, and 2001.174 allows a court sitting in judicial review to consider all of those issues and affirm in whole or in part, remand, reverse. Subsection 2 gives it a laundry list of options for bases to take any of those actions. It might be, as the respondents have suggested, that the Court of Appeals thought that the owner-operator point was just a fundamental part of this case, such that its conclusion on that point vitiated everything. But that's not the case. The point about who the permittee is, or who the owner or operator is an administrative part of the application. It doesn't have anything to do with what the agency calls the technical part of the application, which is the substantive water quality-based determination of what's within the core of the commission's responsibility, that's protecting water quality. And all these other issues go to those distinct questions: anti-degradation review, boron and aluminum, chronic effluent limits. All of those are completely distinct from the owner-operator issue. And these permits are facility-oriented. And what I mean by that is that once a permit is granted, it can be transferred. And the commission's rules on that appear in section 305.64. And so if it were the case, and we think this court should, of course, disagree with the Court of Appeals on owner-operator, but if it agreed with the Court of Appeals on that point, the matter could be remanded to the commission. The commission could reopen the record under 2003.047M, and there could be an amended application that includes an operator. Again, if this court concludes that's what's needed, and that would not affect the rest of the record that's currently before this court. And we're asking this court to reach those other issues in the first instance, even while recognizing that the court typically doesn't do that. It would typically remand to the Court of Appeals for that determination.
Before you get to that, Mr. Davis, I just want to be sure I understand your point. If we agree with you that it's not a jurisdictional problem and that the Court of Appeals could have reached those issues, are you saying it was an abuse of discretion for the court to decline to reach those issues, even if it's not jurisdictional, or did they have the option not to reach those issues?
I suppose the Court of Appeals may have had that option, Your Honor, but as part of judicial efficiency, it should have done what the trial court did. Otherwise, we would have a system where issues would bounce between the commission and the courts, maybe even one issue at a time, because the courts would think that their decision deprived themselves of jurisdiction somehow to reach the others. That's just not how the system is set up, and it would prolong permitting in Texas substantially.
If it's undisputed that a facility has both an owner and an operator that are two separate entities, and one of them files an application just in the normal routine process, is TCEQ going to proceed, or are they going to require the other one to appear?
So that would be within the commission's jurisdiction because there's an application on file. And whether the commission would say, well, let's just hold off and let's make sure we have an operator on here now, or if it would proceed further, I can't answer that. But of course, the statute does require, and the rule requires both the owner and operator to be on there.
Right, so isn't it kind of a standing issue? Because if there's an owner on the application, but it's undisputed that there's a separate distinct entity that is the operator, the decisions that are made on anti-degradation and all the other, they're going to be binding on that operator, even though they're not present to participate in the process.
That's correct, Your Honor, I believe. But again, it's something that could be fixed through a permit amendment. And that's why I'm saying it didn't deprive the courts of jurisdiction to allow that to happen if the court were to conclude that DRCP is not both the owner and the operator. I see I have just a couple of minutes left, and if I could, I'd like to touch upon the second issue I mentioned at the outset, which is the Commission's authority to modify a proposal for a decision. And there are two different statutes that are in contention here. One is the General APA Standard in 2001.058E, and then our contention is that instead of that provision, 2003.047M controls here, because that is the specific provision that governs the Commission's authority to alter a proposal for decision. And we know from subsection N of that provision that to the extent of an inconsistency between 047 and the APA, 047 controls. And here, 047M provides a complete set of instructions to the Commission in particular that's different from the set of instructions provided in 058E, which is more limited. 047 allows the Commission to make any changes it wants as long as they are based in the record, and it provides an explanation of the basis for its changes. And that final requirement essentially would duplicate the final sentence of 058E. And that's, I think, a good indication that these provisions can't be read in tandem because that would require rendering part of one or the other superfluous. And the Commission here satisfied its burden under 047M and 058E too, if the court were to conclude that applies, through its explanation of changes. That's on pages 16 to 18 of the Commission's order. And there, the Commission explains why it made the change with respect to boron and aluminum. It cites the record, including the implementation procedures, Mr. Matzner's testimony about groundwater, the new data that DRCP supplied in September of 2015 about the outfalls. And so it survives that review. I see that my time has expired.
Any other questions? Thank you, Mr. Davis. Thank you. We'll hear from the respondent.
May it please the court, Mr. Frederick will present argument for the respondents.
Good morning. May it please the court. My name is David Frederick. I am appearing on behalf of all of the respondents. We have 2 governmental entities, 2 advocacy organizations, and 5 individuals who live somewhere near the mine who have participated in proceedings to this date. I have prepared and handed out this morning 5 exhibits, which I want you just to know what they are. If we get time to come back and talk with them about them, I'd be happy to. But the first 2, exhibits A and B, those relate to TCEQs. Those are TCEQs, the first one, 1990 acknowledgement that it was acquiescing to EPA and requiring that an operator be an applicant for a permit and be somebody bound by the permit. Exhibit B is EPA's understanding from 1980, and therefore should have been TCEQ's understanding in 1990 of what EPA wanted by requiring an operator to be on the permit. So what were the characteristics of an operator that EPA wanted that TCEQ was trying to, in 1990, comply with? Exhibit C is the answers that TCEQ gave us to interrogatories in the course of the litigation and which were admitted into evidence as part of the record, demonstrating that in 2015, when the interrogatory response was made, TCEQ was operating under a different definition, a different understanding of the same definition, I should say. This is when TCEQ makes it clear to us that it considers only people with financial responsibility to be potential operators. This is just not consistent with what happened in 1990 and with what EPA said it wanted in 1980. The fourth exhibit is from an old case. Well, it's an old case, but not just any old case. It's Texas Railroad Commission v. Shell Oil Company. This is this court's first statement of something having to do with the mere scintilla issue in substantial evidence review. If you track back any case that this court has addressed in the past, I don't know, 5-10 years, you will see that they pretty much all track back to, and raise the scintilla issue. We'll track back to, Texas Health Facilities Commission, or I believe it is, versus Charter Medical Dallas. And then that case, cites a few cases back upstream. And if you look, I have excerpted at the end of Exhibit D, I have excerpted what we can, the respondents, because there'd be the critical language, but certainly have excerpted language that the court used to explain its understanding of the substantial evidence rule and the scintilla issue as it is related to the substantial evidence rule. It's the court's first statement certainly the first statement of anything to do with scintilla, and it's a very, very good statement of what the substantial evidence rule is. 1942, so it's an old case, but it's a thoughtful case. So that's Exhibit D, I guess it is. And then Exhibit E is just the control structure of the owner, the RCP, as explained to us in the trial, and that structure bears on one of the several reasons the county really wants to have the operator be the person on the permit, bound as you would be to a contract, because as that control structure demonstrates to you, I think, getting your hands around DRCP, if that becomes necessary, will be difficult. Let me say first, I think that the Court of Appeals correctly decided what is the legal standard that applies to the person who applies who's going to seek the permit. So the Court of Appeals opinion says, okay, let's figure out what's the definition of operator. Then let's go figure out whether there's substantial evidence to support that definition, support DRCPs having complied with that deposition. That's not the way the briefing to you has come from the petitioners. The briefing to you from the petitioners has just fired off right off the bat, as all people who were trying to reinstate an agency decision do. They say, oh, well, there's not substantial evidence. There was substantial evidence. And after all, substantial evidence is a mere scintilla. It's just some trivial thing better than nothing. I don't think that's the right way to look at it. I think the right way to look at it is let's have a definition of what an operator is. That's what the Court of Appeals did. That's what the Court of Appeals did in Heritage on San Gabriel Homeowners Association a few years ago.
Why should we look anywhere for a definition when there's one right there, responsible for the overall operation of the facility? Isn't that the definition? I mean,
I think what the Court of Appeals said, which I believe to be true, is yes, that's clear. There's nothing in there about financial control.
Why do we need the rest of the gloss from Heritage if we've got a definition right there?
Because now in two cases, somebody has said that's not straightforward. I mean, the Court of Appeals has said twice now, this is not ambiguous. This is what this phrase means. Two other people, corporations, have said otherwise. So, we just don't want to keep arguing. We shouldn't, I don't think, litigate it over and over and over again. But that's why the Court of Appeals lines it all out. All of us think of an operator as somebody who physically does something. I mean, you've got to be turning the valves, lifting the switches, running the equipment, whatever, to be an operator. And I agree with you, Mr. Justice, it doesn't seem that complicated to me, but clearly there are other smart people who disagree.
Well, the word responsible may have some meaning here and sort of potentially distinguish between just the guy whose job it is to flip the switches and the guy who's responsible for ultimately for making sure that the switches are flipped.
Well, but as you've seen from the Court of Appeals opinion, and maybe from the record, DRCP, the owner, has almost no authority on the site. It can act, it can demand action in the case of an emergency. Well, we could all, of course, just argue a lot about what's an emergency. But except for that, DRCP can't do anything on site. So, I mean, you know, I find it hard to believe that people would think DRCP was an operator.
Is the dispute over the definition or the application of the definition to the facts here? And if it's the latter, do the courts owe some deference to the commission's determination? And since the commission determined that the contractor was the operator in the Heritage case, but has determined in this case that the owner is the operator, are both of those decisions, although they go different directions, are they due some deference?
I think because the only reason we do deference is if the definition of operator were ambiguous. We don't think the definition of operator is ambiguous. So separate from the substantial evidence question, sure, the agency gets the benefit of substantial evidence review, but we don't defer to its interpretation of some statutory or regulatory term unless that term is ambiguous. And as the Court of Appeals said, this one isn't ambiguous. So let me turn to the substantial evidence question, if I may.
Before you get to that, can there be more than one operator? And what happens if there is? Do all of the operators have to apply, or is it enough if one applies?
I think you have to have the overall operator.
So there can only be one?
I would say there can only be one. Yeah, I think that's, I mean, I believe overall operations is the term of art that's used in 305.224. And so I think overall, so the general contractor, so to speak. But let's be clear, we don't really have much problem with that in this case. And we've got one very large general contractor, a subsidiary of North American Coal Company, a huge company. There'll be some people come on to like test some water or do something, but there's not going to be any real dispute about who's operating the place. Give or take the dispute about whether the owner's operating the place because the owner supplies the money.
So if there are factors pointing both ways about who's doing the overall operation, and there can only be one, then what is an agency to do at that point?
Like the agency has to make a decision. You know, the agency should make a decision using the proper definition of operator at the time that the permit is issued. And if the person who thinks he or she is an operator doesn't like that decision, or the person who was defined to be an operator doesn't like that decision, then that person or entity has the same power that anybody does in these contested proceedings. You go off to district court, you know, contest it some more.
And so wouldn't that mean that if there's a scintilla of evidence pointing each way and the agency picks one, then the court doesn't get to second guess that as to who the operator is?
No, good. May I move on now to substantial evidence? Because that's what I think is, I mean, the main useful thing I think could come out of an opinion from this court is a restatement of what the substantial evidence rule really is. It is not. It is, as the court said back in 1942, it is not, first, one step at a time. It is only really starting with about, Charter Medical Dallas case, that people began to talk about only anything more, any little increment more than a scintilla would be enough to support the agency decision. Prior to that time, the cases say things like, a mere scintilla is not enough to support the agency decision. So they don't really say, the cases don't say, the mere scintilla is all you have, or one increment more than a mere scintilla is all you have to show. The cases say, a mere scintilla is not enough. People have loosely said, oh, well, then more than a mere scintilla is enough. Well, that's not true. There's a big gap between a scintilla of evidence and substantial evidence, or there could be a big gap between a scintilla and substantial evidence. And that's what's so good about the 1942 opinion, the Railroad Commission v. Shell. We sustain, so looking at the back of D, and I'll read you what I consider to be the important parts, but you and your staff can read the opinion. We will sustain the agency's order if the conclusion is reasonably supported by substantial evidence. This does not mean that a mere scintilla of evidence will suffice. So that's the first time this course has ever talked about mere scintilla, that a mere scintilla of evidence will suffice. Nor does it mean that the court is bound to select the testimony of one side with absolute blindness to that introduced by the other side. After all, the objective is to render justice. The record is to be considered as a whole. Well, that is, of course, the same admonishment or the same instruction that we get from the APA itself. It's the credible evidence in the record as a whole that we look at. So much of the briefing in this case has suggested that the Court of Appeals erred and the respondents are just mistaken because we would go in there and re-weigh the evidence that the agency has already weighed. But there is supposed to be judicial, at least, review of all the evidence that everybody submitted, not just the evidence that is favorable to the agency or favorable to the RCP. And I think that has tended to get lost in recent years. The opinions from this court. Judge Learman had an opinion in Allmon, I'm pronouncing it, A-L-E-M-A-N, v. Texas Medical Board back in 2019. Justice Boyd had one here in PUC versus TIEC this year, in fact this spring, both of which ultimately refer back to, they refer to cases that in turn refer to either Dallas Charter Medical Dallas, or to the case to which that case referred, which is Torchy, some Railroad Commission v. Torchy or Torcho or something, something of that nature. And those cases, once you follow them back upstream, those cases are pretty strong on the need for the court to look at all the evidence that was out there, and then the court gets to decide, could reasonable people, agency, have reached the decision it reached, given the breadth of evidence, all the evidence for both sides that was out there. So anyway, I thought that Court of Appeals opinion was really well thought through and, logical, and I do think it's just not reasonable that someone would think.
Let me ask a question from someone that just doesn't know this area of law as well as you do. What does it matter? Why does it matter whether this contractor is on the application or not when you've got the owner, clearly the owner and the one who has ultimate financial? I mean, I know we've got to construe the rules as written, and if the statutes and rules say it matters, but I'm just trying to figure out, when you've got the owner here who has overall responsibility, at least financially, for the property, and what difference would it make? I mean, if the permit is granted and it has these conditions and requirements, they're going to be binding on this contractor, whether the contractor technically qualifies as the operator or not, right?
Well, no, I mean, that's not clear that they will be binding on the contractor.
So the contractor can violate the permit?
It's binding
He
on
shouldn't
the
violate the
property.
permit, but I mean, you're not going to be able to control that by the contract.
TCEQ can't?
TCEQ could come out there, could probably come out there. I mean, again, it's like a contract. It would be better, I guess, it's like a contract. TCEQ would find it easier sledding to go against the operator if the operator were its permittee. If the operator's not its permittee, if the operator's just some other individual out there, TCEQ, depending on the nature of the violation, can go after that individual.
But if the owner is here, the RCP. The RCP.
Those Republicas Coal Partnership.
Yeah, so DRCP is the owner. Its property, which it has contracted with Camino Real to develop and operate, its property is now subject to all of the conditions and requirements of this permit. The Camino Real may not be, technically, but they certainly are subject to the oversight of the owner with whom they've contracted. So I'm just trying to figure out why in the end this matters to your clients, as opposed to this just being a technicality that you can hold all this up with.
Let me tell you most directly why it matters to my client. My client has enforcement authority. Counties have enforcement authority of TCEQ permits. it would like to have the shortest, most direct path possible to enforcement if enforcement becomes necessary. Secondarily, the applicants for permits have to have their compliance histories developed and presented to the public, and not theoretically, and they may be litigated, or the truths of them or the consequences of those compliance histories may be litigated in these contested proceedings. Right now, the operator, Camino Real Fuels, we don't know anything about its compliance history. The administrative law judge refused to require it to be prepared, said testimony about that was not relevant because there's no law requiring non-operators to have their compliance histories prepared. We don't know what the compliance history would be, but according to the testimony at trial, the compliance history of Camino Real Fuels will be developed in light of violations and complaints and whatnot from its sister companies, of which there probably are 20 or 30 in this country. Oh, I don't know how many there are. There are many, many of them in different states, and its parent company, North American Coal Company. So that's the testimony of one of the DRCP's witnesses. If we'd had all that information, then perhaps because the compliance history allows TCEQ, if the compliance history is not good, the compliance history allows TCEQ to impose limitations on permits that TCEQ either doesn't want to impose normally or possibly legally is even prevented from imposing normally. So in our particular case, there's this argument, which the county didn't much participate in, but it's a valid argument, that there should be a permit limit on barium in the wastewater discharge. TCEQ struck that from the examiner's recommendation and said, no, we're not required to do that. We're not going to do that. Whether it would have done that in the situation where the compliance history of the operator had been shown to be inadequate, that's another question. That's something the county, in this case, the local landowners, might really have prevailed on. There's another one here about monitoring for aluminum discharges in the wastewater. The TCEQ said, no, we don't even have to monitor. Well, clearly, and there's some history of TCEQ having a permittee with a bad compliance record being subjected to increased monitoring. So, anyhow, those are the main reasons. I mean, we've got a park downstream from this mine. We'd like to make sure that we know as much as we can about whoever it is going to be making decisions that affect wastewater discharges that flow through the park. But those are the two main reasons that I believe might motivate my county on this. Let me turn real quickly to the issue that Mr. Davis raised about 2001.058E versus 2003.047M and whether one controls the other. Our position is that they are not inconsistent. They can be interpreted together. But quite honestly, I know you've had pending before you on a petition application now, I bet a year, this Dyer v. Texas Water TCEQ case. It's a great big issue in that case. Lots of folks have weighed in on it. I saw a brief come in the other day from that professor up at Baylor, Ron Beal. So is our position that the opponents are correct, that these two sections can be considered together. But I honestly think awaiting decision on that case would just be a better use of everybody's resources, because I think they will have briefed it better than we, or certainly than TCEQ has thus far.
Any other questions? Thank you, Mr. Frederick.
Thank you.
Ms. Caughey, you have 4 minutes.
Thank you, Your Honor. I'd like to address a few quick points. First, Counsel for Respondents says an operator is always the person who's turning the valve. Well, that's not true. It depends on the applicable text. The United States Supreme Court, in addressing the CERCLA context in Best Foods, directly rejected that view. The explanation from the EPA of operator that he points you to refers to controlling operations. Now, of course, there can be different definitions. Where I started, they put a lot of emphasis in their brief on the Railroad Commission's determination that the contractor here qualified as an operator. But the Railroad Commission deems anybody and everybody who removes a certain amount of coal from the ground an operator. What matters here is the applicable terms, responsible and overall. Second.
Is that how you distinguish the Heritage case? Because in that case, the commission determined that Waste Management, the contractor, was an operator. And so is it consistent with the commission's application in this case to say that the owner was the operator?
The deference to
And what is the difference in these two cases that make the commission's applicable standard seem reasonable?
Number one, the deference to the commission there was correct, and the ultimate decision was correct because there, the person on the permit was the one who was responsible for overall operations in all ways. So however you looked at it, they got it right, but what Heritage got wrong was to the extent it said that operator by definition can only mean the person responsible for its personal performance of causing a mine to function. That's simply not what it said. Now you can distinguish it on the basis that who has to apply for it. One permit isn't necessarily the same as the other, but really what controls here is the applicable plain text. And the plain text is...
But what was the difference between the operator in this case and the operator in the Heritage case, not looking at what the Court of Appeals did, but what the commission did?
Absolutely, Your Honor. When you look at what the commission reasoned in that case, they looked at who was actually controlling overall operations. Once again, this comes back to the notion that you can have an absentee landowner. You can have a situation where there's somebody who owns land but is wholly uninvolved. And there, in that case, Waste Management was the one who, at least when deferring to the commission under the substantial evidence standard, there was more than a scintilla of evidence supporting the notion that they were the ones who controlled overall, were responsible for overall operations, which the same thing here. You look at who on this record with the very deferential substantial evidence standard meets the plain text definition of responsible for overall. And here you asked, who can you enforce against? The evidence shows DRCP had a local office, somebody on site daily, and we signed the permit. You can enforce against us. And the contract and the testimony shows we could fire the contractor. We were the ones who were responsible for overall management, overall operations here. We set the amount of coal to be mined and the quality of coal. We made all the determinations and approved all the plans. Just as you, as a judge, are responsible for your overall opinions, even if your law clerk might assist you, my client, at least there is far more than a scintilla of evidence in the record that shows, was responsible for overall operations. I'd like to briefly touch on the substantial evidence standard, and Justice Bland, you explained it very well in the Ryu case, but you cannot, as the APA says, reweigh the evidence, and City of Keller provides helpful context in the very rare circumstances in which contrary evidence can even be considered, none of which is relevant here.
Any other questions? Thank you, Ms. Caughey. The case is submitted, and the court will take a brief recess.
All rise.